Hello, my name is Jacob Davis, and I'm an attorney in the litigation department at Lazega Johanson LLC. Sometimes when our office is asked to file a collection lawsuit against an owner and we review the information, we see certain clues that indicate something else is going on and the client could be in danger of waiving important rights if we simply plowed forward with the collection lawsuit. Cases with something else going on are really cases for covenant enforcement. This is important because if we had pursued a collections lawsuit but failed to also address past or current covenant violations, you could lose your rights to pursue those violations or related specific assessments or fines. When it comes to dealing with properties that have prior covenant violations, the law requires you to speak now or forever hold your peace. When reviewing collection cases to see if they are really covenant enforcement, there are 3 common clues that we look for. 1 is fines, 2 violation notices, and 3 off-site mailing addresses. As of the first clue, a good rule of thumb is that if a ledger shows fines or specific assessments of any kind, the case is really a covenant enforcement case. And this is often the case even if the violations have been fixed, because it may be necessary for us to prove the underlying violations as well. The second clue is that if the property in question has a prior history of violation notices, this may be a clue that a covenant enforcement case exists, either to remedy the violations, collect assessed fines, or both. Of course, there may be violations that exist, but which a violation notice has not even gone out for yet. For instance, sometimes we find that there are other violations which exist now on the property, but for which no notices have been sent yet. If suit were to be filed without including those violations, the association could lose the ability to enforce them in that case. I have had several cases where violation notices had already gone out for parking violations. However, upon further investigation, I discovered that the reason for the parking violations was that the property had tenants renting the property in violation of the leasing rules and restrictions in that community. Had we filed suit for only the parking violations, the association could have lost the ability to enforce its leasing covenants. Consequently, we often determine that a more detailed review of the property is needed, depending on the facts of the situation, to protect the association's interest. This brings us to the third clue, an off-site mailing address. As an example, I've had numerous cases where the declaration contains a leasing restriction and the owner has all notices for assessments going to an off-site mailing address, but someone is living in the property. In those cases, there is often a leasing violation lurking, which must be included in the lawsuit, or the association may not be able to enforce that violation later. Of course, these and many other factors can all contribute to a determination of whether a case that looks at first glance to just be about collections is really a covenant enforcement case. In working on these types of cases, I'm often able to identify and explain different options and remedies the client may have under its declaration to address various violations. In many cases, I'm able to help the client find options and alternatives to litigation, which can sometimes be more economical. It is important to know these options so you can weigh the legal consequences and requirements and costs against the benefits and make an informed business judgment about how to proceed. One other bonus fact: covenant violation cases often have to be pursued sooner than assessment cases. The statute of limitations, which means how long after a violation starts you have to start a lawsuit, is much shorter for covenant violations. While you have 4 years for assessments, many covenant violations must be brought within 2 years after the violation starts, no matter when you actually find out about it. For this reason, it is imperative to identify early on the cases that should really be treated as covenant enforcement cases. If the covenant enforcement claim isn't brought in time, you may be prohibited from bringing it at all.